Welcome back. Like I said earlier, I'll be running through 9 basic land title documents that you may come across in the course of scouting for land. And I want to start with the basic, and that is family receipt. And a family receipt is a title document that comes into play when you are purchasing land from a family that owns land communally or jointly. When land does not belong to a single individual, or the owners don't have a formal traceable title to the land. Probably the root of the title is traceable to their ancestors, and all they can issue to you is a family receipt signed by the head of family and other principal members of that family. And for you to have legal title with a receipt issued to you by the family, you also have to take physical possession by either farming on the land or fencing the land or erecting a building or other development on the land immediately. That is what grants you legal title over such a land. So that is all about a family receipt. Next to that is a land purchase agreement. Now, when you're talking about land purchase agreement, I always advise that before you go into purchasing land, you need to do your due diligence. But in order to convince the vendors or the assignor who is selling to you that you are serious, you need to perhaps make a commitment of a certain percentage of the purchase price to enable the vendor to part with the title documents, copies of the title documents that he or she has or they have, and to you, so that you can go further and do search in all the necessary places. So the land purchase agreement will spell out the period within which you are to conclude your due diligence, when the balance for a purchase price is to be paid, and all necessary documents or further documents that the vendors or the assignors need to give to you to perfect your title or to prepare a formal deed of assignment that will make that will seal the deal, the transfer of title to you. So that is all about a land purchase agreement. It's very, very essential. Next to that is a survey plan. Now, it's not uncommon for you to see land being advertised for sale, and the title document is expressed to be a survey plan. Now, a survey plan is not a reliable title document. It has to be registered first and foremost. So not just a survey plan. The survey plan has to be registered with the red copy lodged at the Surveyor General's office, the Surveyor General of the state where the land is located. And with that information, you can do a search at the Lands Registry or the Surveyor General's office to be able to discover if that land actually has been registered in that sense. It is not a good title, as it were, but it will identify the land that is being transferred from the assignor to the assignee. And that is so a survey plan is not in itself sufficient to transfer title. It has to go with some other documents that I will be mentioning subsequently. Next to that is power of attorney. And in the course of my experience, legal experience, I've discovered that in some jurisdictions, the power of attorney is the means of transfer of title, because people want to avoid payment of some statutory fees and all the bottlenecks involved in registering title to land. So you find some in some jurisdictions, particularly the eastern part of Nigeria, power of attorney is majorly the means of transferring title. I will tell you that power of attorney is not a good instrument of transfer of title, because it is merely an instrument of delegation of power, and that delegation can be terminated at any point in time. It can only work if such power of attorney is expressed to be irrevocable, based on consideration that has been transferred from the donor to the donee of the power, from the donee to the donor of the power. So that is the only time that it can work as an instrument of transfer of title. So a power of attorney can also come across a power of attorney being expressed as an instrument of title. Next to that is excision and gazette. And it's funny that at times I come across people who say the title to land is gazette or excision, and they seem to confuse it as two different documents. Actually, an excision is a gazette expressing that the government has excised a certain portion of land from an entire land that was formerly under acquisition. So an excision in itself is also a gazette, and it only comes to play where a portion of land, a sizable portion of land, had formerly been acquired by the government for public purpose. And because the law provides that government must pay compensation before such acquisition can take legal effect, you find out that the government usually releases a portion of the land acquired back to the family as compensation to them. And you know what it does is that it gives legal title to the family, and they will be able to sell it at a higher price than if there was no traceable title document to the land, as it were. So a gazette or excision is still talking about one and the same thing. It is a land title document, and people often ask if that is sufficient. When there is a land excision or a gazette on a land, you can decide after purchase to do governance consent or process a C of O over certificate of occupancy over that same portion of land. So that is another title document that you may come across in the course of your scouting. Next, I will be talking about the certificate of occupancy, and this is a document that gives a lot of comfort when it comes to title to land. And it is basically a document issued by either the state government, if the land falls within the jurisdiction of any of the 36 states of the federation, or by the federal government if it falls within the Federal Capital Territory Abuja, and any other land owned by the federal government within any of the states. Although when it is within the states, it is the prerogative of the state governments to issue the certificate of occupancy. Now, it is basically an instrument that declares the holder as the recognized owner of the land, and it came into play by virtue of the Land Use Act, which is the principal statute that governs land ownership in Nigeria. It is usually expressed to be for a certain number of years. In some cases it's 99 years, in some other cases 50 years, 60 years, depending on the use for which the certificate of occupancy has been issued. Once this a certificate of occupancy is issued over a land, it is subsequently you can do another C of O over that same land. You need to subsequent transactions on that land would only accommodate a governor's consent and registration of title of the interest of the buyer, the new buyer, on that particular land. So that is basically what you need to know about a certificate of occupancy. Okay, the next and last document I will be discussing today is the deed of assignment, which is the principal document that expresses the transfer of title from the assigner to the assignee, that is the seller to the buyer. Now, when the title over the land that you are proposing to purchase is a deed of assignment, you need to find out if it has been perfected, that is, the consent of the governor of that state has been sought and obtained over that transaction. If that has not been done, the transaction expressed in that deed of assignment is inchoate, that is, it is not yet perfected, and that needs to be done before title can now pass to you. If that has not been done, there are several other processes that needs to apply. You may need to pay more when you are now doing your deed of assignment, your own perfection of title over the land. So the deed of assignment is the last stage before in land transactions, before you now seek governor's consent and registration of your interest or your title over the land is done. All right, by now you understand the different title documents over land and their legal implications and when they are appropriately used. And if you love this video, please do well to give us a like and click on the subscribe button at the bottom of this video.